The judiciary. The third arm of government is the judiciary. Judicial power is the power to interpret the law and to apply it in the resolution of particular disputes. Judicial power is exercised by the courts. It is the courts who decide whether or not a particular legal rule has been breached, and if it has been breached, what the criminal or civil consequences of that breach should be. Each of the 6 states and the 2 mainland territories has its own court hierarchy. There is also a federal court hierarchy. Each court in the hierarchy has its own jurisdiction, and by jurisdiction we simply mean the types of legal dispute that the court is empowered to resolve. This is a simple diagram of the federal court hierarchy. The reason why courts are usually organized into hierarchies is because it first of all allows a more efficient allocation of court resources. The courts lower in the hierarchy can deal with the more common and simpler type of legal matter, whereas the courts higher in the hierarchy, which generally have more experienced judges, can resolve the more complex or difficult or important types of legal matter. Broadly speaking, there are 3 types of court within the federal court hierarchy. There's the Federal Court of Australia, which exercises jurisdiction over legal matters involving federal law or federal legislation. For example, bankruptcy is regulated by federal legislation, and so when a person is declared bankrupt, that takes place in the Federal Court of Australia. The other federal court lower in the hierarchy is the Family Court of Australia, which resolves legal disputes involving marriage, divorce, the custody of children, and the distribution of property upon divorce. The court at the top of the federal court hierarchy is the High Court of Australia, which is the highest court in Australia. There is only one High Court of Australia. It usually sits in Canberra and is made up of 7 judges. The High Court of Australia only hears legal disputes involving the most important legal matters. Cases involving, for example, the interpretation of the Australian Constitution, or legal disputes between the states or between a state and the Commonwealth Government would be heard by the High Court of Australia. These courts are connected by lines of appeal, which is the second reason why courts are usually organized into hierarchies. If a person is dissatisfied with the outcome of a legal matter heard within one of the lower courts, they may be entitled to appeal from that lower court to a court that's higher within the hierarchy. This is a simple diagram of the state court hierarchy. Most states have a lower court, an intermediate court, and a supreme or superior court, although the names of these courts may differ between the states. Within Queensland, the lowest court is the Magistrates Court. The Magistrates Court hears lower-level civil and criminal matters. So a simple criminal matter such as shoplifting or appealing against a ticket for speeding or for not stopping at a stop sign, these sorts of legal matters would be heard in a Magistrates Court. The District Court in Queensland is the intermediate court within the state court hierarchy. This court would hear more serious civil matters and more serious criminal matters. The Supreme Court of Queensland would hear the most serious type of criminal matter. A person charged with murder, for example, would be tried within the Supreme Court of Queensland. The Supreme Court of Queensland would also hear the most serious civil matters. A person who was suing someone for, say, $1 million would have their matter heard in the Supreme Court of Queensland. These courts are connected by avenues of appeal. So again, if a person is dissatisfied with the decision in one of the lower courts, they may be entitled to appeal that decision to a court higher within the hierarchy. A person who was dissatisfied with the decision of the Supreme Court may be entitled to appeal that decision to the High Court of Australia. The general rule is that the higher one goes within a court hierarchy, the more expensive it becomes, and the longer the matter would take to be heard. The system of dispute resolution used in Australian courts is called the adversarial system. In the adversarial system, the parties to a dispute fight it out in front of an impartial judge. The judge observes and listens to the proceedings, ensures that all the rules of procedure and evidence are applied fairly and consistently, allows both parties to be heard, and unless there's a jury, decides the case. In many ways, the adversarial system of trial is similar to the old system of trial by combat, but instead of giving each party to a dispute a weapon and encouraging them to physically fight it out in order to resolve the dispute, we instead give each party a lawyer. But the notion is still the same. The parties fight it out until there is a winner, who is the person who is deemed to have won the dispute. We can contrast the adversarial system of trial with the inquisitorial system of trial used in civil law countries. You will recall from topic 1 of this course that most legal systems around the world today can be categorized as either a common law legal system or a civil law legal system. One of the differences between these two types of legal system is the way in which trials are conducted. Common law countries usually use the adversarial system of trial, but civil law countries usually use the inquisitorial system of trial. In an inquisitorial system of trial, it is not about winning and losing, but rather the judge assumes responsibility for finding out the truth of the matter. The judge inquires into the legal dispute in order to find out what really happened. In the inquisitorial system of trial, the parties have less control of the case, and instead the matter is under the control of the judge. In an adversarial trial, it is the parties who question the witnesses, for example, whereas in the inquisitorial system of trial, the judge questions the witnesses directly. The decisions of most courts are recorded and published, and this has led to the creation of a second source of law within Australia, case law. Not all aspects of our lives today are regulated by legislation. There are many areas that are regulated instead by the law made by judges, case law. Case law is made up of the collective decisions of judges. There is consistency between the decisions of judges because of the doctrine of precedent. According to the doctrine of precedent, in reaching a decision about a question of law, a court must follow the decisions of courts higher than itself in the same hierarchy of courts within the particular jurisdiction. In other words, if a court is faced with a question of law, and it becomes aware that that same question of law was considered by another court earlier, and that court is higher within the court hierarchy, then the present court has to follow the decision of the earlier court. If the court becomes aware that another court outside of their current court hierarchy has considered that question in the past, the current court is not obliged to follow that previous decision, because it is only required to follow decisions of courts within the same court hierarchy. Nevertheless, the current court may choose to follow that earlier decision, because that earlier decision is said to be persuasive. If the earlier decision was by a superior court in another jurisdiction, and that other jurisdiction has a legal system that is very similar to the current legal system, then the current court is likely to follow that earlier decision. For example, if the District Court of Queensland became aware that the Supreme Court of New South Wales had considered that same question of law earlier in time, the Queensland District Court is not obliged to follow that previous decision, because the New South Wales Court is in a different jurisdiction. But the Queensland District Court is likely to nevertheless follow that earlier decision, because the legal system of New South Wales is very similar to the legal system of Queensland, and the New South Wales Supreme Court is a superior court. Similarly, if a Queensland court became aware of a decision by a UK court that is very similar to the question of law being considered by the Queensland court, it may again choose to follow that previous decision, but is not obliged to do so. An earlier decision by, say, a US court is less likely to be followed because the US legal system is more different than the UK legal system from the Australian legal system. An earlier decision by a Japanese court is very unlikely to be followed because the Japanese system is very different to the Australian legal system. Many of the legal arguments that take place in the courtroom are about which precedents must or should be followed. One of the techniques that lawyers and judges use in order to avoid having to follow an earlier precedent is the practice of distinguishing that precedent. Distinguishing means that there are enough differences in the facts of the current case and the facts of the earlier case to justify the judge not following the decision made in the earlier case. If the court in the current case does decide that the earlier decision can be distinguished, it may create a new legal rule, which itself will become a precedent to be followed by other courts. It's in this way that judges over time gradually create and develop legal rules which form part of the body of case law.